We'll now proceed to our open public comment session. I'm going to give you a few opening instructions, which I believe have been provided to each participant already. Please tailor your remarks to the topic of today's briefing, the conditions of confinement for women in prison. Please state your name for the record. Please note that the U.S. Commission on Civil Rights has a policy not to defame, degrade, or incriminate any person. And given some of the topics that come up with regard to women in prison, I reiterate for public comment participants that since 1983, Congress has prohibited the Commission from taking in any information or talking about abortion. Please tailor your remarks accordingly. Also, this comment period is a time for the commissioners to listen, not to engage in questions or discussion with presenters. We appreciate your testimony and are eager to hear it, and we will not take your short time with questions or dialogue. You will have 3 minutes to speak, which will be measured by this timer. And please notice the box with the 3 lights. When the light turns from green to yellow, that means 1 minute remains. And when the light turns red, you should conclude your statement. And if you do not conclude, I will cut you off. If you have not finished or would like to submit additional comments, we encourage you to do so by mailing or emailing your written submissions to us at the addresses provided on your information sheet on Monday, March 25th. Or by Monday, March 25th, 2019. While waiting for your turn, please sit in the numbered chair that corresponds to your ticket. And in order to reduce time between speakers, we would ask that you move forward to the microphones before the speaker in front of you has finished. Sign interpreters will be signing during their presentations, and if you have questions, please ask a staff member. Some of our commissioners do have flights to catch, and so if somebody has to step up to leave, it is not a comment on your comment, and we apologize for the interruption. So with that, I open for our first public comment presenter.
Me. Good evening, commissioners. I can't begin to tell you how honored I am to be here with you today. Thank you for your time and consideration. My name is Sibylle Fox Richardson. My friends call me Fox Rich, and I bring you greetings from the best city in the world, New Orleans, where I work with our state of Louisiana, along with other stakeholders such as Louisianians for Prison Alternatives, Southern Poverty Law Center, and VOTE, Voice of the Experience, as well as the National Council of Incarcerated and Formerly Incarcerated Women, to bring about criminal justice reform in our state. And we are currently leading the nation in our efforts with the legislation we just passed in 2017. But needless to say, we have a very long way to go. My comment to you today would be to say that first thing that we must do is determine that a thing must be done. And when we determine that something must be done, then we shall find the way. We must end the incarceration of women and girls in the United States of America. We must. Once we come to that understanding, then we shall find the way. It's kind of like paying an electric bill. Once you know that it needs to be paid, you scrape up the money and get it done. For me, I am the mother of 6 sons, a formerly incarcerated woman, and the matriarch of my family who has served 21 years and 4 days in Louisiana's criminal justice system. One of the things that I can say to you is in my time in prison, I had never met someone that could not read or write until I got to prison. And that's where I found them. So education is definitely a key component in our system that we have to address. But the primary thing that I want to discuss with you is about a bill that we are moving through the National Council across the country. And that is the primary caretakers bill. We have got to make sure that when women have children that are under the age of 18 years old, that by any means necessary, we keep that mother with that family. To take a man out of the family destabilizes a family. But in Louisiana, where the majority of people in our system are people of color, when you remove a woman of color from a family, you decimate the family. I had 4 children when I was sentenced to 7 years in prison. I left them with my mother, fortunately, who was able to provide care for them. My husband had been sentenced to 60 years as a first offender in a crime that nobody received medical treatment in. And They wanted to give me 40 years in prison. So I've been home from prison now for 17 years, recently reunited my family. My husband came home through clemency, and we were able to maintain our family, which is not the case for most people. We have to make sure that we keep the women with their children. In slavery in Louisiana, in 1832 to 1865, when a woman incarcerated had a child, it stayed in prison with the mother till it was 10 years old. Are we not more humane?
Thank you very much. And to our next speaker.
Hello, my name is ELISA Benedict, Executive Director of Core Associates. My testimony is a call to action to eliminate harmful disciplinary practices in women's prisons and promote the development and implementation of new systems that align with the research on women we've heard about today. Disciplinary practices in women's prisons are violating basic psychological principles, and they're antithetical to criminal justice goals. They're placing unnecessary financial burdens on departmental and state budgets, increasing the length of women's incarceration, and contributing to adverse outcomes. We must name and elevate this problem, amplify the voices of impacted women, and take collective action immediately. While ineffective for all human beings, discipline approaches in prison have unique and disproportionate impacts on women, most of whom are survivors of trauma and the primary caregivers of dependent children. They restrict contact with family and key relational supports, trigger trauma, and sever women from stabilizing relationships and connections. The disciplinary sanctions that women receive in the name of justice deepen their wounds and create new scars that they bring with them into their communities upon release. I began to advocate for discipline reform in women's prisons many years ago. As a federal partner for the National Resource Center on Justice-Involved Women, I authored the nation's first discipline policy guide with the help of Becky Ney and Andy Moss. As co-founder of the Women's Justice Institute, I've helped cultivate some of the nation's most powerful, quantifiable evidence on disciplinary injustice. In fact, our groundbreaking work and research, including our implementation of the nation's most comprehensive women's prison assessment, spurred and substantively shaped a 15-state investigation by the Chicago Reporter, NPR, and the Medill School of Journalism that was published in 2018. You heard about that today. The Women's Justice Institute's cutting-edge research has revealed the following important realities. Women are disciplined at higher rates than men and receive harsher penalties, often for nonviolent infractions. Women of color and those who identify as LGBTQ suffer unique injustices within the system. They're uniquely problematic for women suffering with mental health challenges, including PTSD. In fact, these practices worsen mental health challenges and create ones that didn't exist before incarceration. They're increasing women's length of imprisonment and taxpayer costs. They include mandatory sentences for repeated infractions that encourage things like stacking of charges and discipline, which has serious impacts on women's earned good time, limits their access to programs, limits visits with children, and prevents them from having early release parole opportunities. They're fortified by grievance processes where staff intimidation, retaliation, and coercion prevent women from accessing their rights as human beings. When women speak about their experiences, they're often not believed and engage in survival behaviors for which they're punished. In the matrix of criminal justice system reform, disciplinary practice in the women's prisons around this country represent a human rights crisis. This testimony is a call to action that includes 5 steps. Each state should assemble a team to explore disciplinary trends in women's facilities, develop a plan to provide staff with immediate training and coaching, actively engage directly impacted women.
We'll need
Thank
to take
you.
the rest. Thank you.
My name is Katherine Shevchenko, and I am the counsel for the National Council for Incarcerated and Formerly Incarcerated Women and Girls. The National Council is the only national organization that was founded and is run by incarcerated and formerly incarcerated women and girls. You may remember us as the voice of the women in prisons who drafted part of the Dignity Act, which has been mentioned many times today. Our goal is unabashedly to end the incarceration of women and girls, but in the meantime, we also work to address the conditions of confinement for those who are currently incarcerated. We would like to ask for you to continue your critical oversight and engagement with this issue, but we also invite you to go beyond reimagining prisons. And ask you to reimagine the criminal justice system itself. Please explore innovations such as bail funds, participatory defense, and statutes that keep primary caregivers out of prison and at home with their children. If they were here, the members of the National Council would speak about the difference between what prison officials say and how the system really works. As Ms. Burton did, they would tell you how all the problems that we have learned about today affect the lives of women, their children, and their families. The recent scathing report of the Department of Justice, OIG, on the conditions of incarcerated women confirms the lived experience of National Council members. We are grateful for your work and in particular for the care that you have used in the language that you have used today so as not to re-traumatize women who have experienced incarceration. But any reform is useless if it is not implemented well. And the First Step Act is the latest example. The BOP claims it is implementing the law, but the view from the prison bunk is very different. And I would like to share with you now some actual responses from a survey we have received from women across the country who are inside. The prison is not helpful with any information about the First Step Act. They aren't correctly applying credits nor communicating with us about when or how it will affect any of our sentences. They seem to act as if it is not official or real at this time. Whenever we ask the warden or any high administrator about the FSA, they either don't know, or they've never heard of it, or they say it doesn't apply to you. So we urge you to continue educating the public about the disastrous condition in American prisons and to make sure that the promises to the incarcerated are kept. Thank you, and free her.
Thank you.
Puneet Chima on behalf of Lambda Legal, the nation's oldest and largest legal organization dedicated to the rights of LGBT people and those living with HIV. We've represented incarcerated transgender women in leading impact cases affirming their rights. Our comments today cover 3 areas of concern for transgender women in prison: housing placement, protection from sexual assault, and access to necessary medical care. First, transgender women are too often housed in men's facilities. PREA requires facilities to give serious consideration to trans women's views if they wish to be housed consistently with their gender identity. However, many facilities completely disregard this and place them in men's facilities based on their sex assigned at birth. This subjects them to intense sexual harassment and risks of sexual assault. Just such a case in North Carolina made the news today. Ms. Kanata Zare Brown has surgically transitioned, but been placed in a men's dorm and subjected to daily harassment, according to news reports, despite repeatedly requesting to be housed in a women's facility. To mitigate the risk of violence against transgender women in men's facilities, many facilities then place them in protective custody, effectively long-term solitary confinement. In addition to negatively affecting their mental health, it makes it difficult for trans women to access education, training, recreation, employment, and other services that result in good time credit, ultimately causing them to serve more time in custody. Trans women should be afforded the option to be housed according to their gender identity or wherever they feel and are safest. Second, more must be done to protect trans women from sexual violence. The rates of sexual assault against incarcerated trans women by both other inmates as well as staff are horrific. A 2009 survey of California prisons estimated that trans people are 13 times more likely to be sexually assaulted. The Bureau of Justice Statistics puts this rate at 10 times more likely. Passion Star, a Lambda Legal client, was housed in 6 male facilities in Texas, where she was identified as feminine, raped, and forced to submit to undesired sexual acts to escape violence. She filed dozens of grievances, complaints, and requests to be placed in safekeeping, but instead of taking measures to protect her, officials told her to fight or stop acting gay if she did not want to be assaulted. Eventually, after years of litigation and advocacy by Lambda Legal, on behalf of Ms. Starr, she was released on parole. More must be done by facilities to prevent sexual violence against trans women, to thoroughly investigate it when it occurs, provide medical service to survivors, and hold perpetrators accountable. Finally, incarcerated trans women must be provided necessary access to medical care as required by the 8th Amendment. While courts, the medical community, and most correctional facilities now recognize gender dysphoria as a serious medical condition, facilities continue to limit the type of medical care that is available to trans women and remain unwilling to provide transition-related surgeries when they are medically necessary. Facilities also deny trans women access to gender-appropriate clothing and personal items, refusing them the ability to groom themselves in a manner consistent with their gender identity. This can lead to daily humiliation and exacerbate gender dysphoria, harming their health. It may also expose facilities to liability when these items are medically necessary to treat gender dysphoria. State prisons and jails must do more to ensure they are not violating trans women's rights and endangering them through inappropriate housing decisions by failing to protect them from sexual assault and limiting their access to medical care.
Very much appreciate this public testimony. We understand that there is one other person who is traveling, so the commission is going to recess, and we will stay here until 6. And if the person gets here, we'll take that testimony as well. Thanks very much. Thank you. So we're returning from recess. Thank you for your extraordinary efforts to come for public comment. I'll just share the instructions for public comment. Given some of the topics that can come up with regard to women in prison, I reiterate for public comment purposes that since 1983, Congress has prohibited the Commission from taking in any information about or talking about abortion, so please tailor your remarks accordingly. Thanks. And if necessary, I will enforce that statutory restriction. This comment period is a time for the commissioners to listen, not to engage in questions or discussion with presenters. We appreciate your testimony and are honored and eager to hear it, and we will not take your short time with questions or with dialogue. You'll have 3 minutes to speak, which we measured by a timer. And please notice this box with 3 lights here. When the light turns from green to yellow, that means 1 minute remains. When the light turns red, you should conclude your statement, and otherwise I will need to cut you off. So we look forward to your testimony. Please proceed.
Good evening. Thank you so much for waiting for me. They don't call me Grace for nothing. Thank you so much. I am Kelly Grace Price from the Close Rosies organization. We're a group of survivors of the Rose M. Singer Center, the all-female jail on the notorious Rikers Island jail complex in New York City. I thank you for holding this hearing and for allowing me to appear in front of you. I want to address my comments specifically to PREA, the Prison Rape Elimination Act in New York City jails. I know that this particular hearing is engaged around women and girls in prisons, but of course you can't get to prison in this country until you are in jail first. And I specifically have one ask of the commission, and I'll get to that. I ended up on Rikers Island as a survivor of domestic violence. My batterer was connected to the NYPD, and the Manhattan District Attorney used him as a confidential informant to sweep through Upper Manhattan and make all kinds of big RICO gang busts. You may or may not be familiar with the person who has the title of Manhattan District Attorney, Cyrus Vance. He is one of the main leaders in an national anti-gun movement. So a lot of people like me end up on Rikers Island. A lot of innocent people end up on Rikers Island because as women, we're caught between the Scylla and Charybdis of circumstances that take us there, even though we absolutely are not guilty of the crimes committed. In fact, you should know that the people that end up on the Rose M. Singer Center on Rikers Island, the women and girls, only 28% of us eventually take a guilty plea or a plea bargain out. So basically that means less than 30% of us are actually guilty in the first place. This is not a place where rape and sexual assault should run amok. We should not be re-persecuted as innocents when we're put in this jail. For the past 7 years, I have spent advocating to implement PREA in our city jails, specifically on Rikers, and our oversight board, the Board of Correction that is predominantly appointed by our mayor, has failed miserably to implement PREA. After much community to and fro, in the summer of 2016, a PREA rule was proffered forward. It was voted on to much dissent in November of 2016 to be implemented beginning in January of 2017. To date, of the over 100 different aspects, the facet of different rules to be implemented, cameras, reporting, investigations, staffing, less than 10% of them have been implemented. There's absolutely no oversight. And I know that the commission has the power to convene hearings, to subpoena leaders, and I'll provide much greater at length written testimony, but I ask this commission to start with New York City. This is the place where Now was born. This is a place where my grandmother ate pizza on the steps of City Hall as a suffragette. We need to protect our most vulnerable citizens, especially if we're innocent. Thank you for listening to me. Thank you for having me.
Thank you.
Thanks.
And with that, we are closing the record for the day. Thank you very much.
Thank you so much.